Scheme 2016, and it's from Deputy Jonathan O'Brien. Deputy O'Brien.
This is in relation, as you pointed out, the Tenant Incremental Purchase Scheme 2016, which was offered by local authority to their tenants, giving them the opportunity to buy their home. Minister, as you will be aware, there are certain categories of houses within the ownership of local authorities which cannot be sold to tenants under legislation, and these include properties which have been transferred to a planning authority in accordance with an agreement under sections 96 of the Planning and Development Act. In other words, Part 5 houses. If the developer builds a private estate, a certain percentage of them is handed over to the local authority. If you are a council tenant in one of those properties, you are unable to ever buy your home under the legislation. Now, Minister, the reason I raise it is twofold. One, I am wondering if the Department have any plans to just review that and have a once-off offer made to those tenants. For instance, I'm dealing with a constituent at the moment who is a tenant in one of these properties for the last 10 years. She qualifies under all of the other criteria. In other words, she's a tenant for over 10 years. She's within the income limits, but unfortunately, she's in this category of houses under the legislation which cannot be sold or cannot be transferred. The sad thing about this is this particular tenant will probably never have the opportunity to buy their own home, unless there is some review of the current legislation. They don't earn enough to get a mortgage to buy a brand new home, and the whole point of a tenant purchase scheme is to allow tenants who have been living in a local authority house the opportunity to buy their home at a reduced cost. The second issue I want to raise, Minister, in relation to it is local authorities themselves. This particular lady actually got a letter in June 2011 offering asking for expressions of interest under the 2011 scheme. Now, at that moment in time, they didn't go ahead with it because they didn't meet the other criteria. In other words, she wasn't a tenant for 10 years. But this year they actually got another letter requesting an expression of interest, which was sent out in August 2016. Now, I have no issue with the letter, because the letter clearly states on behalf of Cork County Council that you are only qualified for the scheme if you are occupying a property which is available for sale from Cork County Council, and it refers you to the tenant handbook, where it outlines the properties which you are not able to buy. Unfortunately, the tenant didn't refer to the handbook, but my issue is the council have a list of these properties. They shouldn't be sending out letters to tenants by name and address to houses under the scheme when they know very well from the outset you cannot buy one of these houses under the scheme. She got the letter on the 17th of August. She gave her expression of interest. They asked for a set of accounts for her husband, herself. She went through all that rigmarole. She gave her €100 deposit. And it took the council 3 months to actually write back and inform her that she wasn't eligible under the legislation. Now, sadly, hopes were raised that she was finally going to be in a position to buy her own home, but that's not the case, Minister. So, just on those two issues, is there any plans to look at the scheme for a once-off derogation to allow tenants the opportunity to buy their home under this legislation?
Thank you, Deputy. Minister.
Thanks, Chair Ciancrola. Just to thank Deputy O'Brien. Unfortunately, the Minister can't be here this afternoon himself, so he's asked me just to take the topical issue. The Tenants Incremental Purchase Scheme came into operation on 1 January 2016 and is open to eligible tenants, including joint tenants of local authority housing, that are available for sale under the scheme. The housing sale of Local Authority Housing Regulation 2015 governing the scheme provides a number of specific classification of houses to be included for the sale. For example, units provided to local authority under Part 5 of the Planning and Development Act 2000 as amended, houses designed for occupation for older people, group traveller housing and houses provided for persons with disabilities, making them transition from congregated settings to community-based living. Local authorities can also exclude houses for reason of proper estate management of its stock, in accordance on these structural conditions or on account of proposals that authority may have to carry out remedial work in the estate concerned or to regenerate the area in which the house is located. The provision of Part 5 of the Planning and Development Act 2000 as amended are designed to enable the development of mixed tenure suitable communities. Part 5 units are excluded from the tenancy incremental purchase scheme to ensure that the units delivered under the mechanism will remain available for people's needs on the social housing support, and that the original policy goal of legislation are not eroded over time. The continued development of mixed tenure communities remain very important to promoting social integration. Part 3 of the 2014 Act also obliged tenants to meet certain criteria in order to be able to for the scheme. This includes having a minimum recoverable income of £15,000 per annum and having been in receipt of social housing support for at least 1 year. In the determination of the minimum recognition income, housing authorities can include income from a number of different sources and classes, such as from employment, private pensions, maintenance payments and certain local social welfare payments, including pensions, while the social welfare payment is secondary to employment income. I understand there are maybe some tenants whose application under the scheme have been refused on the basis that do not meet this income criteria. This element of the scheme rules introduction in order to ensure that substantial of the scheme itself. Sustainability of the scheme itself. It is essential that application incomes in long-term and suitable nature. There is necessary to ensure that the tenant's purchase of the house is in a financial position as the owners to maintain and insure the property for the duration of charge period in compliance with the conditions of the order of transferring the ownership and responsibility of the houses from the local authority to the tenants.
Thank you very much, Minister. Deputy O'Brien.
Mr. and I thank you for your answer. Look, I think this comes down to an issue where I can understand the regulations. I'm not going to argue with that. I can understand that they were put in place to ensure that communities were mixed, of a mixed tenure, and to enable integration. But the reality is, if this tenant bought a house in the morning, she's still the same tenant. You know, she's not going to change the makeup of the community because she's gone from social housing and she now bought her house under a tenant purchase scheme. I can understand completely if the property was designed for somebody with a disability, then obviously it would be in the best interest of the council to maintain that property in the longer term, because if that tenant ever passed on or moved into residential care and that property became available, there is a huge shortage of specially designed properties for people with disabilities. So I could understand a council not wanting to sell a property under those circumstances. But if we're talking about a 3-bedroom semi-detached house, which hasn't been upgraded or refurbished for somebody with disability, this is a family who have been living there for 10 years and under the current legislation will never ever have the opportunity to buy their own home, the home that they've been living in for the last 10 years. So I would again ask, Minister, that you would go back to Minister Coveney and maybe give him the transcripts of this debate and ask him to consider or even to look at the possibility of having a once-off break in the legislation to allow people the opportunity to buy their own home. I'm not saying it has to be open-ended. You could put a time frame on it, the same as happened in 2011. The scheme was opened up for 12 months and then it was closed. But I would ask that the Part 5 element of the Planning and Development Act would be looked at for a specific period of time to allow people to express their interest.
Thanks, I've taken a number of notes on what you've said, Deputy O'Brien. I just want to read this in line with the comment given in the Rebuilding Ireland Action Plan from Housing and Homeless. A review of all aspects of the first 12 months of the scheme operating is currently being undertaken in the Minister's Department in close consultation with local authorities. Minister Coveney will of course consider the need for any change in the terms and conditions of the scheme based on the evidence presented by the review. The Minister expects that the review will be complete by the end of the Q1 of 2017. As part of the review process, my department is currently engaged in a public consultation process which will inform the outcome of the review. I will I will encourage all of those interested in the scheme to make contribution to the process. Full details of how it will be to do this will be found on the department's website. And can I just add, Ceann Comhairle, I've taken note of the particular reference to a resident who received the letter from Cork County Council and then unfortunately was disappointed at the fact that for some reason the council had made a mistake in sending out a letter and giving the family an opportunity to buy the property, which wasn't really what they should have done, and it was very unfair, and I can understand the frustration and the disappointment by them. And I just want to concur with some of the sentiments that the Deputy has made himself.
Thank you very much, Minister. That therefore concludes our consideration of today's topical issues, and we will now move on. The next item to be considered is the second stage of the Disability Miscellaneous Provisions Bill 2016. And I call on the Minister of State at the Department of Justice